A very good morning to these students. This is a revision lecture on our syllabus of jurisprudence, and the topic which we have selected is Unit 5, Liability. That is, we'll have a revision over our entire Unit 5 of liability, wherein we'll study about the definition of the liabilities, then what is remedial liability, what is penal liability, with the concept of the doctrine of mens rea, and finally the strict and vicarious liability. So let's begin our lecture. Number one, what is the definition of liability? When we talk about definition of liability, liability in a simple sense means which result from a wrong of breach of duty, which means I have a duty being assigned, and if I do a breach of my duty, that arises a liability. It is something which a person must do or suffer on account of his failure to do what he ought to have done duty. Suppose I have a duty that I should not harm anyone's character, personality while I'm in a public speaking. Now, if I defame anyone, then that is my breach of duty, and then liability arose. So a person has a choice in filling his duty, but liability arises independently of his one's choice. Definition of liability given by Salmon was, it is a bond of necessity that exists between the wrongdoer and the remedy of the wrong, has more often been said to have a contract or delegate, which means Salmon said that liability is a bond of necessity between the wrongdoer and the remedy of the wrong. Suppose I have defamed person X, so I am the wrongdoer and the remedy of the wrong is compensation. So that is liability which arises out of a bond of necessity. Another aspect is that liability is independent on one's own choice, because which means that if I have failed to perform my duty, I have done a breach of my duty, I would be liable irrespective of my choice, wherein fulfilling one's duty is based upon one's choice. Now, when we talk about remedial liability is the concept which is based upon the point that ubi jus ibi remedium. That means where there is a right, there is a remedy. So law creates or imposes duty. It also enforces certain specific performance. For any breach of duty, there is a remedy available into the law. And those remedy can be in the form of compensation, damages, or pecuniary compensation. But there are certain exceptions to this where duty will not be enforced, which means where if there is a breach of duty, there is no remedy or any kind of aspect available to it. Those are duties of imperfect obligation. In the first place, duties of imperfect obligation wherein there is no remedy. For example, time barred debt. Though the debt exists in law, but it is unenforceable, which means after 3 years or 12 years in the case of property, 3 years in the case of money, once the time bar debt has taken place, after that it is enforceable. So which means if there is a breach of duty in that, there is no remedy available in the law, because it is duty of imperfect obligation. Next is duty which by nature are incapable of specific performance. Another exception to this rule is that duties of such nature which once broken cannot be specifically enforced. For example, in an act done by the defendant cannot be made to refrain from it, which means once the person has performed the act, he cannot specifically enforce or refrain from it. Everyone has a right to reputation, and therefore there is a corresponding duty imposed on others not to violate such rights. But if at a libel is committed, the specific enforcement of corresponding duty of the defendant, that is the person who has committed libel, is not possible. In other words, once a mischief has been done, it cannot be undone. In such cases, damages are perhaps the only advocate remedy available. That is, duties of nature which are incapable of specific performance, which means there cannot be any specific performance. Once it has been performed, it cannot be undone, and perhaps the damages or the remedy available for this is just to claim damages, advocate damages. The last kinds of exception is where specific performance is expedient and inadvisable, which means there are cases where thought of specific performance of duty is plausible. The feud does not enforce its specific performance, but rather awards damages to the plaintiff. For example, law does not enforce specific performance of a promise of marriage or painting to a picture, but normally award damages in such cases, which means there is no such specific performance is inadvisable. But to some extent, if the extreme condition is there, then the damages can be provided, the remedy can be available. Thus, the purpose of remedial liability is to ensure specific enforcement of plaintiff rather than punishing the wrongdoer. According to the theory of remedial liability, whenever a law creates a duty, it should enforce the fulfillment of such duty. Law imposes remedial liability on those who fails to perform such duty. Briefly, ordinarily duty is enforced by law except in the following cases where law will not enforce the same. That is the exceptions which we have done: duties of imperfect obligation, incapable of specific performance, and specific performance where it is inadvisable or inexpedient. For example, in the case of marriage, court would not insist on enforcing a marriage. So the aspect of remedial liability is that you have a duty to be performed, and if there is a breach of duty of that, available remedy is available to you in the course of law to fulfillment of such duty. So remedial liability basically focus on enforcement of plaintiff's right rather than the defendant wrongdoer. So the point of remedial liability is to focus on the aspect of creating a right and liabilities of the plaintiff, and whoever has failed to perform the duty will be made liable to pay compensation damages out of it such, whereas remedial liability gives a remedy or a way to attain or to get damages in the form of compensation, pecuniary compensation, or any another kind of a reliefs. In certain three aspects, exceptions which we have discussed, in that case, the concept of remedial liability, that is law, would not take into course of enforcement. That is duty of imperfect obligation, for example, in time bar debt. Next, duty of incapable specific performance, which means once it has been performed, you cannot undone it. For example, in the case of right of reputation. Next, specific performance is inexpedient or inadvisable. For example, in the case of marriage, their court cannot pass an order to enforce the marriage where you have promised for a marriage. In all above cases, duty is there, but it cannot be enforced. So the remedy is lost. In all the above cases of the exceptions, duty is there, but they cannot be enforced. So remedy is lost. But wherever there is a right, there is a remedy involved, which gives the plaintiff the obligation to protect its rights and liabilities. So this is the theory of the remedial liability. Now let's move on to the concept of penal liability. Penal liability is based on the point of actus non fecit rem nisi mensit rea. That is, act itself does not constitute or amount to a crime unless it is accompanied by a guilty mind. So there are two aspects needed to impose the concept of theory of the penal liability, that is actus reus and mens reus, that is guilty mind and guilty act, which means no person can be punished merely because of his act which has resulted into some crimes unless it has been accompanied by a guilty mind. So therein also, if there is a guilty mind but there was not some guilty act, so both need to constitute to commit an offense. Thus act is physical element of the crime and mens rea is the mental element. Generally a man does hold criminally liable only for his wrongful acts which he has done either willfully or negligently. There are however some exceptional cases where law imposes strict liability, wherein irrespective of the fact whether mental element was there or not, but he has committed an offense against public health or licensing acts. In such cases, the act itself becomes punishable even without the presence of guilty mind and negligence. So criminal law basically focus on the point of punishing the wrongdoer. So commonly the point is that if the constituted the element of actus reus and mens rea, which means a guilty mind and a guilty act has taken place to commit that a criminal offense, then the concept of penal liability would take place, wherein penal liability aim is to punish the wrongdoer, and such punishments can be like imprisonment, death sentence, life imprisonment or fine, both. So the theory of the penal liability is based on the concept of actus non fecit rem nisi mensit rea, that is, it need to have a guilty mind, that is the physical mental element, and a guilty act, that is a physical element, to constitute the crime. And if these things are proved, then the concept of penal liability in the forms takes place. Another aspect is that there are certain cases in which irrespective whether a guilty mind or negligent has been taken place, if the person has committed an offense which is against public health, morale, and that imposes the concept of strict liability, which we'll discuss in later on. Thus, if we put a difference between remedial liability and a penal liability, the point is that remedial liability is based on a point of ubi jus ibi remedium, that is where there is right, there is remedy. Penal liability is based on the concept of actus non facit rem nisi mensit rea, which means act itself does not constitute a crime. We need a guilty mind and a guilty act. Next concept, remedial liability give a way to protect the rights and the liabilities of the plaintiff. Penal liability give a way to punish the wrongdoer. Remedial liability, the remedy available is compensation, damages, pecuniary compensation. In this penal liability, the liability arises, or the punishment is the punishing the wrongdoers, either self-imprisonment, imprisonment, rigorous imprisonment, or life imprisonment, death sentence, or imprisonment and fine, both. So these are the differences between remedial and a penal liability. Now let's move on to the concept of mens rea, that is the doctrine of mens rea. What is the meaning of mens rea? What are the constituent elements for the mens rea? What is its doctrine and what are its exceptions? Now, if we talk about mens rea is based on a point that it is a mental element of a criminal act, which is accompanied with a point that a person need to have a guilty mind to commit a particular crime, either that may be either intentionally, recklessly, or negligently. Generally, the knowledge of the consequences is considered as a part of mens rea, because mental condition of man would determine his conduct over to committing of the crime. So guilty mind, that is mens rea, have two forms: wrongful intention and culpable negligence. A person shall be punished if he intensely and willfully does an act which is prohibited by the criminal law. He shall also be made liable if he does a forbidden act negligently and carelessly without bothering about the consequences, which means he was knowing the act that it is forbidden by law, but either negligently or carelessly he has done that act irrespective of the consequences. However, some exceptional cases when a person is held liable irrespective of his wrongful intention or culpable negligence, such cases are covered under what is known as strict liability. Thus, wrong incurring penal liability or of three kinds, considering from the point of view of mens rea. So if we talk about under the aspect of mens rea, the wrong are considered under penal liability are three. First, intentional or willful wrongs, then the wrongs of negligence, and also the wrongs of strict liability, which are independent of mens rea, which means that in mens rea we need to have a guilty mind. That guilty mind can be intentionally and willfully. Sometimes it can be out of negligence and carelessness, irrespective of knowing the fact that it is forbidden by law, irrespective ignoring it, that what would be the consequences of it. And the last, wrongs done under strict liability, which is an independent of mens rea, which means certain cases where guilty mind is not needed, but if you have committed an offense which is against the public health, morale, irrespective whether it has done negligently or without a guilty mind, you would be liable under the concept of strict liability. Thus, to conclude on a point, that mens rea is an essential element for a crime. It is the mental element for a crime. Now, if we talk about what is the application of doctrine of mens rea, so we can see that the position of mens rea is very much applicable in the criminal law. The learned author of criminal law in India has pointed out that every offense is defined under the states, not only what the accused must have done, but also with regard to the state of mind. For example, theft must involve dishonestly, cheating must be committed fraudulently, murder must be committed either intentionally or knowingly. Thus, there is no need for a general doctrine of mens rea, as whatever elements under the Indian Penal Code has been defined with the criminal offences, with its elements to constitute a crime, all such elements constitute the concept of the mens rea. All that prosecution has to do is to prove that the ingredients to a particular offense which the accused is alleged to have committed that. So the point is that the application of doctrine of mens rea, if we talk about under the Indian law, there is no such application needed, because whatever the provisions of the committing a crime under the Indian Penal Code, either it is theft or murder or cheating, all are mentioned with the concept of the guilty mind and mens rea. So it has been enshrined, or you can say it has been formulated in such aspect where all the aspect of definitions, including the mens rea, has been made self-sufficient to make the definition of the offense. So this is the concept or application of mens rea under the doctrine of mens rea under our Indian law. Now, when we talk about what are the exceptions to the cases of mens rea, certain exception, one exception we have already discussed, that in the case of strict liability, that in the strict liability there is no requirement of mens rea. If you have committed an offense which is against public health, like food, drugs, public safety, social welfare, you would be given a imposement of strict liability irrespective whether mens rea was there or not. Next cases where it is difficult to prove mens rea and the penalties are petty fines. The expediency demands that suspension of the requirement of mens rea would facilitate speedy disposal of trial. The accused can be fined even without proof of mens rea. Next exception is it is necessary to make mens rea into consideration in deciding cases related to public nuisance. It is so in the interest of the public safety. So in the cases where it is related to public nuisance, public safety, public health, it is not necessary to have mens rea. The next exception is mens rea is unnecessary in those cases which are criminal in form, but in fact they are only summary mode of civil right, enforcing a civil right, which means it is criminal in form, but the remedy available is enforcing a civil right. In that case, the mens rea is unnecessary. Mens rea is not relevant in cases in which plea of ignorance of law is raised as in defense. In such cases, the fact that offender was not aware of the rule of law and that he did not intend to violate it is no defense. He shall be liable even if he didn't knew the law, and mens rea would not be applicable in that concept. So these are certain 5 exceptions in the concept of mens rea, where there is not a guilty mind or anything, but if you have committed an offense, you would be held liable. Let's understand it with 2 of the case laws for a better provision. In the case of R versus Tolson, in this case, a woman whose husband has deserted her married another man before the expiry of 7 years, which was against the English law in relation to the marriage. The jury, however, found that woman not guilty of bigamy as the bona fide belief that her husband had died. The court acquitted her of the charge of bigamy as mens rea was not proved in this case. Thus, mere act does not constitute an offense unless it is coupled with a concept of mens rea. Next case is State of Gujarat versus Acharya Devendra Prasad G. Pandey. The case was defined in this case mens rea as some blameworthy mental condition, whether constituted by knowledge or intention or otherwise. Generally, the term guilty mind is associated with intention. Therefore, traditional view of equating mens rea with guilty mind seems to be erroneous and misleading. So that is the point, that if mens rea is related to one's intention and claim, then that constitutes for an element, mental element for the crime. With this concept, we had completed our concept of remedial liability, penal liability, its differences, the concept of mens rea, doctrine with its application under the Indian law and its exceptions. Now let's move on to the next topic on our liability, that is negligence. Now what is negligence? When we talk about negligence, that is a second form of mens rea. It is basically an offenses in which mens rea is a necessary element of the wrongful intention, which means a person has carelessly or recklessly with a mental attitude have performed certain act which has led to the violation of its breach of duty. Salmond has defined negligence as state of mind of undue indifference towards one's conduct and its consequences. Austin said that an omission is not consequence of an act of the will, but the state of mind which has styled the negligence and implied the absence of will and intention, which means that mens rea is an important element in the aspect of negligence, but certain state of mind which you have conducted with an undue indifference towards one conduct which lead to the concept of creating a negligence. Thus, negligence essentially consists in mental attitude of undue indifference with respect to one's conduct and its consequences. Now, when we talk about kinds of negligence, see, negligence is the concept that I know that particular act is forbidden by law, but carelessly or recklessly, with my state of mind of undue difference, I have committed that act. That state of mind of undue indifferences with the consequences is the negligence. Now suppose I have kept a hazardous substance in my locality. I was knowing the fact that keeping it is an illegal or it is unlawful, but still I kept it, due to which it escaped and it caused the damages to my neighbor. So that means my carelessness, undue indifference attitude led to causing consequences to the next party. That is negligence. Now, if we talk about kinds of negligence, there are two kinds: advertent negligence and inadvertent negligence. Advertent negligence is called willful negligence or recklessness, which means by willfully I have committed an act knowing it that it was the harm foreseen was possible or probable, but I have not willed it, I have still done it. For example, a person who drives furiously at a high speed in a crowded street, knowing that it is a crowded street, I'm driving it at 100 km per hour, it may cause harm and injury, but still I have done it, and that is for the legal purpose, that is negligence with an intention, which means with my willful recklessness and carelessness. Next is inadvertent negligence, which talks about my ignorance, my thoughtfulness, or forgetfulness, which means I did not have any kind of an intention, but my ignorance towards that act, my thoughtfulness or forgetfulness towards that act have led to commit that negligent act. For example, a doctor doing a operation wherein he left the scissors into the stomach of the patient. Now there, either by thoughtfulness or forgetfulness, he is the guilty of an act guilty of an act which is out of its ignorance, and that is known as inadvertent negligence. Now, when we talk about degrees of negligence, there are three kinds of degrees of negligence. That is culpa laeta, culpa levis in abstracta, and culpa levis in concreto, which means these degrees determine to know whether the particular act is negligent on the nature of its conduct. Now, degree lata means failure to show any reasonable care at all, which means gross negligence, which a prudence man would commit, which means I know that I have to take a reasonable care, but I've forgotten to take in all the reasonable care at all. That is culpa lata. Next is culpa levis in abstracto, which means failure to take the responsible as the head of the family, which I have to take while I was entering into a contract with any another party for the benefit of the family, which means suppose the karta is the head of the family. Being the head of the family, he has certain liabilities that has to create a benefit towards his family. But irrespective of that failure to take reasonable care, I entered into a contract which causes a defect to my family. That is culpa levis in abstracto. Next is culpa levis in concreto, which means failure of a person to take a care which in an ordinary course of affair he would have simply taken it. Simple word, it means failure to exercise ordinary diligence as against extraordinary diligence, which means that I have to take a reasonable care to carry out my part of failure towards the ordinary course of business, but I fail to do so in dealing with these affairs, and this has caused a negligent act towards my diligent act. Now, these are the concept of negligence with the concept of the degrees of negligence, which help us to determine the nature of conduct of the person with the aspect of kinds of negligence. Now let's move on to the theories of negligence, which means what are the two theories which determine the concept of negligence. The two theories are subjective and objective theory. Now subjective theory was given by Salmond and objective theory was given by just jurist Pollock. Now let's discuss the theory, both the theories one by one. When we talk about subjective theory, it simply means that negligence is a subjective way of one's thought. That is, it is the culpable carelessness. It is the thoughtfulness on inadvertentness. Therefore, according to this view, negligence is considered the mental attitude of undue influence with one's respect of conduct or consequence. A person is made liable on the ground of negligence because he has not sufficiently desired to avoid that particular consequence, which means that the person was knowing to the fact of that point that it will cause an adverse effect onto the other party consequences, but he failed to avoid that particular consequence harm, and that led to the committing his carelessness and recklessness act to commit the crime of negligence. For example, your inadvertent negligence would be under the concept of subjective theory. That is, my recklessness, my carelessness, thoughtfulness, attitude, my undue indifference led towards the act of committing that crime. That is advertent negligence. Knowing the fact that I'm driving in a crowded street at 100 km/h, it will cause consequences and harm, but I did not insufficiently took any desire to avoid that, due to which I led to the act of committing negligence. Next is objective theory, which says that negligence is not attitude of a mind, but my way of conduct. It is my breach of duty to take care, which simply means that I have to take a duty to take care, but my particular act has not refrain me from taking that unreasonable duty of the care, my diligent, and due to which I have failed to achieve my objective standard of a reasonable man, and due to which I committed the offense. So objective theory basically says that negligence is not state of mind, but my conduct of an act, which means my act of carelessness, unreasonableness has led to commit that particular crime. So both these two theories stand applicable into the concept of negligence and make it clear that sometimes negligence can be a person's state of mind of undue indifference, his thoughtfulness, his forgetfulness, his recklessness or carelessness. Sometimes the negligent act of a person can be through his way of conduct rather than through the state of mind. Let's understand it with a case law much better. One of the famous case law on this point is Dango versus Stevenson, which I think most of you might already know, that a manufacturer has manufactured a ginger beer and sold to the retailer. Now, when a ex went on a date with his fiancée, lady friend, fiancée wife, and he ordered that bottle of ginger beer. Now, when they poured a bottle of ginger beer, there was a snail inside it, and when she drank, she fell ill. Now, she sued the manufacturer, and it was held that yes, the manufacturer has to take an account of a duty of a care, which he failed to do so. He did not check while making the ginger beer bottles to be manufacturing. He failed to do so, and that has caused a harm to the party. That is why plaintiff, that is why he would be liable for the negligent act. So herein the concept of objective theory came into picture, that my way of conduct, irrespective of my state of mind, my way or conduct or my action of conduct has conducted a breach of duty, which in an ordinary course I have to take as a reasonable person, prudent man, which I failed to do so, and I am held liable for that negligent act. Next is Dixon versus Reuters. Now, in this case, A sent a telegram to B for shipment of the certain goods. Telegram company by mistake delivered it to C, and now C sent those goods to A. So A refused to pay the amount to C. C sued these telegram companies, but the telegram company was not liable to the negligent act of C, but was liable to the negligent act which they have committed against A. So herein subjective theory comes into picture, that my state of mind of undue inference, my state of mind of thoughtfulness, forgetfulness, my recklessness, attitude made a loss to the party A, which means telegram company has to deliver it to B and he did it to C. So he is liable for the negligent act to the party A rather than to the C. So with this concept, we complete the point of negligence, the concept of negligent, wherein we came to the aspect of one particular point, that negligent is my way of state of mind of undue indifference, which means my thoughtfulness, unforgetfulness, recklessness, carelessness lead to my negligent act. Now, it is based on the concept of two theory, that is subjective and objective. Subjective is that it is related to my state of mind. An objective, that sometimes my negligent act can be due to my way of conduct rather than my state of mind. Now let's move on to the another topic of the syllabus of unit 5 on liability, that is strict liability and vicarious liability. Now we have already discussed strict liability while we were doing that. Strict liability is one of the exceptions of the mens rea, but let's understand it much better. Now, the principle of strict liability has been erased from the case of Rallen versus Fletcher, wherein you might be aware with the facts that one of the person was creating an unhazardous substances in his premises, and that substances escaped and caused the damages to the consequences to the plaintiff, and with that, due to damages, and that plaintiff was suffered a huge loss and damages to his property which has escaped, and thus the liability imposed on him was because, not because of his negligent act, but because of a point that he has kept an hazardous and dangerous substances. So when the judicial pronouncement of the concept of strict liability was done, therein came as an three essentials to constitute a strict liability. That number one, there must be a dangerous substance, then that dangerous substance have escaped out of your land, and that has caused a non-natural use of land and caused the damage to the third party. So the concept of strict liability brings on a point that irrespective on the point that whether you have committed a negligent act or whether you have committed an act of mental element or not, but you have committed a crime which has caused a consequences to the third party, which is against the public safety, public morality, public health, irrespective of the fact whether you constitute a mental element or not, you have committed an offense and you would be liable under the concept of strict liability. Three essentials are needed to constitute the concept of strict liability. That is, that hazardous substance must be there, then that substance have escaped out of your land, and there has been non-natural use of the land. The concept of strict liability was propounded in the case of Rowland versus Fletcher in the year 1868, which states clearly that if any person who keeps hazardous substance on his premises would be held responsible if such substances escape from his and causes any damage to the another party. But there are certain exceptions to the strict liability wherein the party would not be liable, and those exceptions are number one, plaintiff's fault, which means if the plaintiff by own his fault has caused damage, irrespective of the point of defendant's act, then defendant would not be liable because plaintiff himself came in a contact with that dangerous thing. In the judicial pronouncing of the Pointing versus Noakes, the plaintiff horse died after it entered the property of the defendant and ate some poisonous leaf. The court held that it was wrongful intrusion and the defendant was not held strictly liable for the loss because the plaintiff's horse escaped from his land and entered into the property of the defendant. So it was not the defendant who gave him the poisonous leaves. So therefore it was own fault of the plaintiff that he did not take care of his horse. Next is act of God, which means vis major, which simply means that any such act which is out of the control of the human, and if it is done by the natural reasons, by the God Act, then it can be prevented from exercising the concept of the strict liability. The defendant won't be liable for the loss if the dangerous substance escaped because of some unforeseen or natural conditions that could be controlled in any manner. Next is act of the third party. Now, the rule does not apply when the damages is caused neither by the plaintiff nor by the defendant, but by the third party, wherein defendant do not have any such way to control the third party, and where the acts of the third party can be foreseen, but the defendant must take due care, otherwise he will be held liable. So wherein it was out of the control of the defendant to know, control the third, if he is knowing and he control it, then he has to take a due care, which he has not done, then he would be liable. But if he did not knew it and then he's unable to control the third party, and due to the act of third party the consequences have been caused, then he would not be liable. For instance, in the case of Box versus June, where the reservoir of the defendant overflowed because of the third party emptied his drain through the defendant's reservoir, court held that the defendant wouldn't be liable. The next exception is consent of the plaintiff. This exception follows the principle of voluntary non-fit injuria, which says that suppose, for example, A and B are neighbors and they share the same water source which is situated on the land of A. And if the water escape and causes damage to the B, he cannot claim damages as A would be liable because both of them are using it together. That means the consent of the plaintiff has been given. So these are certain exceptions into the concept of the strict liability. Now let's move on to the case laws to understand it much better. The Rowland versus Fletcher is the case law which talks about of the concept of the land, which gave the principle of the strict liability. Next is which I have already discussed with you in the dealing with the introduction to the strict liability. Next is Hollins versus Fowler. It was held that if a person meddles with the goods of another person in absolute innocence and under an inevitable mistake of act, mistake of fact, he shall nonetheless liable for all the loss incurred by the true owner, which means that if a person has in absolute innocence have done an inevitable act, so he would not be liable. Next, in the case of Stanley versus Power, it is a leading decision on inevitable accident as a defense. In this, defendant was firing at a peasant and accidentally, without a negligent shot, the plaintiff was felt from his gun. It was held as a good defense because it was an inevitable accident, and a defense could be taken under the concept of the strict liability. So with this, we conclude the point of the strict liability. We came into conclusion that strict liability need three essentials to constitute: that you have a dangerous substance that has escaped from your compound, and has there been non-natural use of the land. If all these three things are proved, then the concept of strict liability will came into picture, without the aspect that you have a mental element or not to constitute the crime. Certain exceptions are in this, that when it is plaintiff's own fault, when it is act of God, when it is the concept of voluntary non-fit injuria, or when it is the act of the third party, therein it will not be liable for the concept of strict liability. Now, the next kind of liability which we have to discuss is the concept of vicarious liability. Now, the vicarious liability is based on the principle of the concept that for the acts of the person, or his own acts would be, there is a general concept that acts of one person would not be liable with the acts of another. But in the case of vicarious liability, a person is liable for the act of another on the account that he's having a particular kind of a relationship with that person. This is called vicarious liability. The principle of vicarious liability is based on a point that a person would be liable for the acts of the another person, provided that acts has been done in the during course of the employment. Now, when we talk about the concept of vicarious liability, we can find that vicarious liability is more applicable in the case of a civil liability, wherein a master is held for all the tortious liability of the acts done by his servant in the course of employment, or the representative of a dead person is liable for the acts of the deceased. But in the case of criminal act law, vicarious liability does not hold so good importance unless the provision provided under the criminal law talks about the vicarious liability. So the simple form of vicarious liability is that a person is held liable for the acts of another, provided that there is a particular relationship between those two and that act has been done during the course of employment. In the case of civil law, there are two aspects: that a master is held liable for the acts of the servant in the course of employment, a principal is held liable for the acts of agent during the course of employment, a representative is held liable of the dead person is held liable for the acts of the deceased. Now, master is held liable for the acts of the servant, provided that that act has been done during the course of the employment. And then during the course of that employment, the master would be held liable for the acts of the servant. Now, suppose Mr. A is the master and B is the servant. Mr. A has given certain money to Mr. B to buy particular product. Now, when he went to buy the particular product, he committed a forgery with the shopkeeper, or a theft. He stole certain items from that. So the point is that herein master would be liable for the acts of the servant, because the servant was acting during the course of the employment. Now, under the criminal law, if we talk about under criminal law, there is no such aspect of the concept of that a master would be liable for the act of the servant, or a principal would be liable for the acts of the servant. But if the statute imposes that criminal liability, that a master would be liable for the act of the servant, then in that case, if the statute law provides with that point, then the master would be liable for the acts of servant. Otherwise, vicarious liability hold a stronger concept towards the civil law rather than under the criminal law. Let's understand it better with two of the case laws. In the case of Fletch versus Baltimore, in this company, workers were coming after from their work. They used to throw timber near to the houses from the train. One day while going so, it injured the pedestrian. He sought damages from the master and liable because after knowing such thing, he failed to give her proper information, which means that company was returning from their home using the company's car and throwing timber outside, which caused a pedestrian injured. In that case, he would be liable for the acts of the servant, because knowing the fact, he failed to give a proper information. Next is H&N Bolton Engineering Company Limited versus TJ Graham and Sons. In this case, it was held that if it was also had hands which to hold the tools and act in accordance with the direction from the center. Some of the people in the company were mere servants and the agents. In this case, it was simply held that a company is run by the principals and the agents and the directors and the managers, who are the will of the company, the mind, the state of the company. Now, if they do particular act, then that state of mind would be liable for the managers of the company, and they would treat it under the law as to be committed by the masters as well as servant, and they all would be held liable because they kept quiet knowing the fact. So this is the concept of vicarious liability, wherein the master would be liable for the acts of the servant, provided that they enter person would be liable for the acts of the servant, provided that there is a particular relationship between them and that act has been committed during the course of employment. Now, with this student, we have completed the concept of liability, wherein we studied about the definition of the liability. Then we studied about remedial and penal liability with its differences. Then we studied about the mens rea, the definition of the doctrine of mens rea, its essential, then application of doctrine of mens rea in India with its exception. Then we studied about the concept of negligence, wherein we studied about its definition given by various jurists. We studied about different types of negligence, that is true, advertent and inadvertent. Then we study about degrees of negligence, which help us to determine the state whether the particular act is negligent or not. And we concluded it with the point of theories of negligence and the case laws. Then we came to the point of concept of strict liability, wherein we studied that this principle was developed by Rell and Fletchers with its essentials and exceptions. And then we studied about the concept of vicarious liability, wherein we studied that what is its position under the civil law and under the criminal law. With this, I conclude your revision lecture on liability. Any doubt further on this, you can contact me through the mail. Further, I will be providing you the assignment for the same, and I request you read the question diligently and then do the assignment and submit it on time. Thank you and have a good day.